What's up, guys? I hope you're doing well today. Lighting is darker than it was just a moment ago. I hope everybody's doing well today. It is Tuesday. What day? It's Tuesday, September the 12th. And I just had tacos. They were delicious. I'd love to hear what you had for dinner tonight. If you didn't like what you had for dinner, go ahead and tell me what you wish you had. Um, I just, you just saw my face go like that because that's a med check. Because I was like, wow, I ate those tacos. I really enjoyed them. That's because I wasn't medicated. So now I have to medicate, and so should you. If you take medication, please go ahead and think about doing that. If you don't, come down to the chat and let us know what that's like. We haven't met a lot of people like that. So, whatever, I'll find it. Beverly, you had tacos as well? I know. I mean, it's taco night, right? That sounds delicious. Mine were really good. I'll post a picture on the Discord later. Orlando Chiquita! The storm was crazy last night. You had tree limbs flying everywhere. Luckily, no damage. Oh my goodness. Please be safe. Who else is here? Let me take a look at who is here today. Oh, oh, this is a great reminder for everybody else. Switch from top chat to live chat, unlike me. Lisa B, MB, Mayor, Wrench McGnome, Grammy Rita, Jody Gardner, Daylight Disinfectant, T-Rex Trucking is here, RLS is here, Jay from Michigan is here. Um, uh, who else did I see? Oh, Streamlabs. Um, she's a maker. You were only 89 seconds late today? Man, I was probably more late than that. Um, Sashina is here. Presto. Oh no. Really, Presto? So Presto's just written a weird preview of upcoming events. A police officer got pew-pewed in Clayton County yesterday by your job. So we got that first appearance, is what I think you mean to say, to look forward to. I was like, aperceive. Is that some word I don't know? Fancy word? Vicky is here, Vicky Pathless. And like I said, Donna, Orlando Chiquita. Oh, Melanie's here too. Did I miss Melanie? Hi, Melanie. I don't. And Tin Man. Hi, Tin Man. KH is here. It's French. It's French. Um. Oh, Billy Elliot, you're here too. It's French. I'm French. No, I'm not. I'm not French. We know that. Hundy P. Okay. So Trash Talking Tuesday, I'm sure that's why most of you have tuned in, but that actually is going to be on a number of different levels today. So, starting with something from one of our favorite friends in the chat, Hector Cam Clips, a channel that I feature on my list of court adjacent babies. Um, Hector sent me two clips today into my office in Discord. Thank you, Hector. One of them we're going to get started with, and then we actually are going to go to Canada and we're going to read through a Canadian case. It'll be a little different than our normal evening, but the trash talk in this case, oh my goodness. So, and then of course, there'll be me. I'm here. So, please make sure that you've clocked in for your shift by hitting that like button. Go ahead. Courtney's here. Oh, Courtney, you stayed up. You're so sweet. I do feel bad. I know, I've somehow shifted into an earlier time slot on even being on the West Coast here, but we'll see where we get to. Canada, is that a real place? No, it is not. It's where we speak French. Oh yeah. So take your meds, which I haven't done yet. I'm gonna have to go look for those. So take your meds. I'm slut, yeah. Hi Loud Elvis. You guys are great. What a Tuesday it's been. What a trashy Tuesday. No, I'm just joking. What a great Tuesday it's been actually so far. Like I said, please clock in for your shift. It's so helpful. It's such an easy click for you to subscribe and to make sure that you've liked the video. I'm gonna ask you to do it, please and thank you. Uh, trying to decide which stream. Oh, you thought you had COVID. That's not good. Hi, Frosty Jim. Welcome. Um, MB, you're hilarious. Don't say it too much. We did so good the other night. I'm so proud of everybody ignoring. Med check, check your smoke detectors. That's a good thing to do. If they're beeping, guys, change them. Just change them. It's so simple. Um, I think I've put it out here before. Like, if you don't have a fucking battery, just like let us know. We'll get you a battery. Anyways. Uh, like I said, Tuesday, September 12th. Oh, let's do my quick American lesson. And in anticipation of my trip down south. Today the weather has been quite gray up here in Canada. Although it does say it's 17 degrees, which I find hard to believe. But 17 degrees in Celsius is a whopping 62 degrees. So that's my lesson for the day. 62 degrees. It was 98 degrees there, Courtney. Like I said, I had tacos for dinner. They were delicious. Okay. Anyways, we're gonna go ahead. We're gonna watch this clip from Hector. Hector's titled it "Judge Getting Sarcastic When Defendant Wants a New Public Defender." So let's see how that goes. Oh, I've also just realized I don't have my eye makeup. That's fine. That'll be us today. Okay, let's get going.
F-240, State of Wisconsin versus Alberta Martin. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Eugene Harrington, Defense Counsel in person. Ms. Martin appears by video conferencing in custody at the at the Bayfield County Jail. We're set today in this matter for a bond modification request. The court has reviewed the motion submitted. Mr. Harrington, you may continue and argue.
Your Honor, I think the court should have a conversation with Ms. Martin first. If I understand the conclusion of our telephone conversation last night, she no longer wants me to represent her, I think is what the
all right, I can ask her, and I can let you know, though, Ms. Martin, that it's not your choice if you get to fire or ask Mr. Harrington not to continue. That would be my choice, and it's based upon certain factors, and you would have to produce certain information and evidence and testimony for me to weigh to determine if the court would grant your request to have a different attorney. Ms. Martin, is that accurate? Is Mr. Harrington, his statement about perhaps you wanting a different attorney accurate?
Yes, I did tell him that.
Okay. Now, is that what you want? You're looking for the court to listen to you to determine whether or not I will grant your request, or are you satisfied with Mr. Harrington and want to proceed?
Well, he doesn't represent me the way that he should represent somebody as a public defender, a lawyer.
Oh, how do you know? Did you go to law school?
Well, no, but I've been in the system for.
Oh, snap, Judge. Holy shit. Oh, we gotta hear that again. Oh, she a little. It like hit me afterwards. Oh, honey. Oh, also, Melanie, thank you. Appreciate it.
Well, he doesn't represent me the way that he should represent somebody as a public defender, a lawyer.
Oh, how do you know? Did you go to law school?
Well, no, but I've been in the system for quite a long time to know,
Oh, so
how.
you,
I'm a prolific criminal. This is the argument that we're getting right now? She's a prolific criminal. Many times have I dealt with, I mean, Judge, I've probably seen more lawyers than you have. Wow.
oh, you have the system knowledge. So now tell me though, I need to know because again, I have to look at certain things such as I have to look at your complaints, what they exactly are, the timeliness of them, how close are we to any type of hearing or resolution or trial in your matter. I also have to look at, what this type of conflict may be and determine whether or not it results in what's called a total lack of communication, which would prevent an adequate defense. And we're talking an adequate defense. Is he doing his job effectively? The law says look at ineffective, but again, there's plenty of case law there. The Court of Appeals makes it very clear as what is ineffective or not. And does this conflict frustrate your ability to have a fair presentation of your case to the court and to a jury? So what are your issues?
Well, I brought up a couple things that I wanted to present him before you, and without him even, writing it down, he always just gave me a quick answer, a negative answer to give, that he gave me.
Oh, you didn't like his response to something you requested?
That was negative. He said, I don't know if he's trained you in or what, but he also threw that in there, as I know she's gonna deny it. Well, how does he know that? Just because he trained you in there? That's what he told me, he trained you in.
Well, for the record, yes. Mr. Harrington, I'm going to tell you, I was an attorney in front of him. Ooh. He was a strong judge. He nipped and he picked, but yes, but he was fair. Now he's a public defender. And then I became a judge and he was my mentor judge, yes, for the first year. Then he retired. Now he's practicing in front of me. Now I'm just as hard on him as he was on me.
If I may, Your Honor.
You may.
Understand.
We had a conversation, Ms. Martin and I had a conversation last evening. She asked me about the petition for bail modification. I gave her my estimate as to what the court would do with it, and I told her why. And she said, you're being too negative. And then she said, well, how about getting me back to Burnett County so that I can bail out down there? And I was about to explain to her that the Burnett County Jail is being remodeled in construction process and that they had shipped all of their females out. And that's when she told me I was too negative and that I wasn't representing her, and she hung up. And that's why I brought this up to the court. Quite frankly, Judge, the impression I got from her was that she views it is my privilege to represent her, and that's not how I view this.
And that is not even accurate or correct. The fact that you have a public defender appointed to you does not mean you get to decide that you don't like a public defender. You don't get a choice of attorney because you get an attorney to be appointed to you. That's what the law is. Not a choice of an attorney, not an attorney that's going to give you rainbows and butterflies. You have a very experienced lawyer in front of you, or who was representing you, a very experienced lawyer who knows the law inside and out. And he does, for all intents and purposes, he may have an inside track as to probably how I think, not only because he mentored me for a year or whatever it was my first year.
Wow. Also, I would just like to point out I used that phrase today, all intents and purposes, and I wrote it properly. Pretty proud of myself for that. Also, if you're just getting here, make sure you clock in for your shift. This is a little clip we're going to watch. before we dive into actually going to be some Canadian court, but of course, Canadian court is not broadcasted the same. So you'll have to do with my voice reading it. But let's continue. And thank you again, Hector.
But the fact that he sits in front of me for the last 4 years and he's practiced in front of me, and any attorney who sits in front of me can probably get an idea of where I'm going to go and what I'm going to do. I'm very clear, I'm very blunt, I'm very open. And you don't have the right to choose your attorney, but I'm going to say that I am going to grant the request and I'm going to remove Mr. Harrington from the case, not because I feel that you've met your burden as to the factors, but because quite honestly, I'm going to let him move on and use his services to somebody else who may need his services. So at this time, the court is going to remove Mr. Harrington from your case. You need to reapply to the public defender's office, and then they'll hopefully get an attorney appointed to you soon. We are set for a status on October 5th at 9 o'clock. And then, so hopefully you'll have an attorney appointed to you by then. As to the bond modification, he is correct. I'm denying it. There's no new information. You failed to come to court 3 times. And that's the whole purpose of bail, is to assure your appearance. And the fact that you cannot appear even by video is appalling. And so I'm leaving the bail set at what it is. You're going to apply for a new public defender. They will get one appointed to your case. Thank you. We are adjourned.
Thank you. Next. Is that the next? That's what she said there. Holy shit. Give me 1 second. My phone's going off. Look at me. That was crazy. That was pretty crazy for the judge. Thank you, Hector, for bringing that one to my attention. Give me 1 sec. This is going to be okay. So I don't know if you can actually see it as clearly as I want you to be able to, but it's as clear as I can get it for everybody. I don't know that I can read it from there. I might need to like move myself over so I can read it over here. So I'm gonna have to move this over. Yeah, hold on. I gotta move something. But I'm thinking, yeah, that should do. That should be fine. No, it won't be fine. Come on. Okay, so this is a case that we talked about recently, and if you're new here, I am Canadian. Always mention it. Never forgotten. I have to still. Well, I am Canadian, and uh, I like court in Canada too. I would love to watch more of that. It's just really not as available because we don't broadcast court in the same way. But I am lucky enough to have found a few different cases. Hold on. I really should have practiced this first. I practiced most angles first, but I forgot this. Also, Tin Man, Streamlabs doesn't know what he's talking about with the fucking dismissal thing. So this was in 2017, and this is actually going to be a bit of an ongoing series that we read through all of this guy's cases because I find it very interesting, and he is a dick. Allegedly. No, I don't even know if it's allegedly at this point. I think it's pretty standard that he is. But irregardless, I know what I'm going to do. Duplicate the tab. And then I'll put it up on here where I can see it. I guess I'll have to sort of... Oh yeah, that'll work. Oh yeah. Oh, but I'm going to have to scroll with you guys. And that's okay. We'll make it work, I think. Anyways, this case I talked about recently, and this is a Supreme Court of British Columbia ruling in the case. And please note that there is a publication ban based on the court's inherent jurisdiction that prohibits the publication of the names of two young people referred to as G and S. So, in this case, I'm hopeful that they've done their own redacting. I'm going to go ahead and make sure that we try and adhere to that. Um, the site for this is RV Fox 2017 BCSC 2361, and it was in Vancouver, British Columbia. It was before the Honorable Madam Justice H. Holmes, and these are her oral reasons for sentence. So, the accused was Patrick Henry Fox, and the date of trial was September and part of November 2017. He appeared in person, and like I said, I will go ahead and start reading this. If this is not your thing, don't worry about it. I will see you next time. But this is part of what we're doing tonight, and I hope you enjoy. So it says, introduction. A jury found Patrick Fox guilty of two offenses. First, criminally harassing. Oh, I'm gonna redact her name as well, but they haven't. So just pretend like you don't see it. I'm gonna say the wife. Is what I'm gonna say. So a jury found Patrick Fox guilty of two offenses. Number one, criminally harassing his ex-wife, who is his former spouse, and causing her to reasonably fear for her safety or the safety of people she knows, contrary to Section 264 of the Criminal Code. And number two, being in possession of firearms at a place other than where he was authorized to possess them, contrary to Section 93, subsection 1 of the Criminal Code. The criminal harassment took place between January 11th and May 27th, 2016. Throughout that period, on the Crown's evidence in trial, while the firearms offense took place between May 17th, 2016 and June 3rd, 2016. The task now is to determine the appropriate sentences. So in outlining the circumstances of the offenses, I bear in mind the principles in section 724, subsection 2 of the Criminal Code, and more detailed guidance in R.V. Ferguson, 2008, Supreme Court of Canada 6 at paragraph 16 through 18, subsection 724. 2 addresses how the facts are to be determined after a jury trial, given that the jury gives only its verdict without reasons, and its material parts read as follows. Number 2, where the court is composed of a judge and a jury, the court A shall accept as proven all facts, expressed or implied, that are essential to the jury's verdict of guilty, and may find any other relevant fact that was disclosed by evidence at the trial to be proven. The judge says, I will begin by outlining the circumstances of the criminal harassment offense. So, in a brief overview, Mr. Fox conducted a campaign as he put it, make his ex-wife's life as miserable as possible, hoping to drive her to unalive if that could be done within the confines of the law. It was a campaign conducted by means of hundreds, probably thousands of emails that he sent her, and sometimes to people she knew, as well as by means of a website that he created in her name. These communications were designed to embarrass and humiliate her by disseminating personal information about her, to undermine her relationships with her family members, friends, and employers and work colleagues, to ruin her financially by preventing her from keeping or gaining employment, and generally to intimidate her. Before I describe the criminal harassment in greater detail, I will briefly outline the relationship that they once had. They first met in January 2000 in Arizona, where they both lived at the time. He was in his mid-20s and she was 19. They married in August of that year, and their son G was born prematurely shortly afterwards. The marriage broke down the following year, and a high conflict custody dispute followed. At one point, a joint custody order provided for G to spend some of his time with Mr. Fox, who lived in California at the time, and some of his time with the mother, who lived in Florida. That arrangement continued for a while, but by late 2001 or early 2002, G was with Mr. Fox entirely and had almost no contact at all with the mother for approximately 10 years. Mr. Fox and the mother have different positions about the reason for the change from shared custody to the absence or exclusion of the mother as a parent. Contact between the mother and G resumed in mid or late 2011, and so too did the custody dispute. Court proceedings in California eventually led to an order for joint custody under which G would live mainly with Mr. Fox and would visit his mother on school breaks. That arrangement went relatively smoothly until, in late 2012, Mr. Fox advised his ex-wife that he was thinking about moving to Vancouver, British Columbia to take up a job offer, and he asked for her consent to take G with him. The mother did not agree, and Mr. Fox filed a motion with the California court seeking authority to take G to Canada and to have her access time with G suspended. Okay. So let's just pause there for 1 second. I apologize as I read this. I can't really read the chat as well and keep up with it. You want ASMR voice for the second half of the document? I'm scrolling up now. So this again, we've talked about this case earlier before, but this is so sad. Whenever there's parents that are, unable to put themselves to the side and just be adults, it makes me really sad, to be honest with you. And the reason, hold on, let me just scroll through something. I read that, I glanced over this earlier. I was like, this is gonna be so short. You're gonna need to oh, Jesus Christ. Anyways, what we're gonna do, we're gonna read through. Here we go. So after he sought authority to take G to Canada and have her access time suspended, the mother understood that Mr. Fox had been living and working illegally in the United States of America. Fearing that he would succeed in taking G to Canada, the mother, on 2 occasions in late 2012 and early 2013, notified U.S. immigration authorities of his status in the USA as she understood it and his whereabouts. You can find, I'll put it in the chat. Hold on. This is on the BC Supreme Court website, so I'll link it. 1 second. I just have to bring up the chat. Oh, come here, chat. Come here, chat. There you go. Oh, there should probably be an L at the end of that. And then see if that works. There we go. Oh, they both worked. Anyways, okay. So, Sashina, what are you saying sorry for? Don't be sorry. Okay, so there, if anybody wants, is the actual case you can follow along and read with. Where are we at? So, on both occasions, he was removed from the United States without the child, which is crazy to me. It sounds like why would they let him back in? If after the first time he got removed because he wasn't supposed to be in the States and he was working there illegally. Like, that seems a little crazy to me. But anyways, Mr. Fox has lived in Canada since early 2013 after he was removed from the USA for the second time. In the fall of 2013, G began visiting him during school breaks and continued these visits for most of the time until early 2016 when Mr. Fox was detained on these charges in custody on these charges on June 16, 2016, after having been detained by U.S. authorities the month before. Back in 2013, following his removal from the USA, Mr. Fox told his ex-wife that if she did not return G to him, he would devote the rest of his life to destroying her within the confines of the law. In or around early 2014, he created the website in his ex-wife's name containing a very large amount of private information about her and the people associated with her. The website includes a welcome message that includes the following. This is now literally this is under quote. This is like what he actually has on the website. It says, the goal of this website is to increase awareness of blanked name here, his ex-wife, by informing the public of the atrocious, the despicable, and the downright evil things my ex has done. We hope that by publishing the truth together with hard proof, e.g., police reports, court testimony, recordings of the countless horrendous acts she has been committing all her life, we may help others to avoid being manipulated, exploited, and harmed by this seemingly charming and sweet sociopath. Wow. See what I mean by trash talk? The website includes personal details about the ex-wife as well as purportedly biographical details and information about her character, preferences, and history. It includes dozens, probably hundreds, of photographs of her in various aspects of her life, sometimes also showing her children, including her son in his underwear. Weird. Her current partner and her previous partners, and the interior of her home. The website details the location of the home with maps. The website also details the history of the custody dispute from Mr. Fox's perspective and includes copies of the vast email correspondences between him and her. Another section of the website focuses individual by individual on the people associated with her, and these include her younger son, S, her mother and father, and her current partner and his mother, and dozens of her friends and work associates. A photograph of each person is shown together with contact information and a description in, it seems, as much detail as Mr. Fox was able to gather. Jay from Michigan, if he's not a Canadian citizen, Canada will send his ass back across the border real fast. No, he's not a U.S. citizen. He is Canadian, and that's why he's allowed here. He's working illegally in the United States, which is why I wonder why he's even been able to go back there. Hi, Mikey. Hope you're doing well. I'm doing Canadian court tonight. It's a little different. I'm reading some of it. This guy's a fucking loser, though. He's a trash talker and a real jerk. So, let's continue here. It says, a further section purports to detail contact by her and people associated with her with courts of different types of jurisdiction in the USA. And finally, a series of dozens of blogs or posts, most of them purportedly written by her, contains content designed to humiliate and degrade her. What? So he wrote in, like, pretending to be her, writing in her diary, and then posted them on there, which is, again, fucking weird. Oh my gosh. Please remember I'm reading this. For example, one post has her purportedly declaring, in some detail, raging hatred of people of non-white ethnic background. Another post entitled, An Open Letter to All Prospective Employers Why You Should Hire Me, speaks sarcastically and in vulgar language, purportedly in her voice, about why she should be hired, the given reasons all weighing heavily against her, e.g., I've never accepted responsibility for anything, which is okay because so far there's always been someone else to blame it on. Dude. Oh, wow. That's crazy to me. Like, how much of a baby is he? In an email in March 2014, Mr. Fox told her about the website. He told her he had sent a link to the website to her colleagues at work, as in fact, he had taunted her that colleagues would read about what a fool and poor parent she was, and would see her in her underwear. What? Her underwear? He sent generally similar emails and many others on countless other subjects over the course of the next several years. I will highlight a few examples. Thank you, Judge. Appreciate that. Love it, love it, love it, love it. For example, in December 2014, shortly before the period of the indictment, Mr. Fox outlined in clear terms in an email titled The Ugly Proof. So much time, right? His objective and the approach he would be taking. He emphasized that his approach was a long-term one. Quote, I'm methodical and I think things through. I look at the long term. Sometimes my plans take years to complete, but I always see them through. Mr. Fox also noted that he had a changed identity as Patrick Fox with a squeaky clean background, and he traveled easily into the USA, and that he had hand pew-pews, although he noted, as he always did, that his statements and references to his firearms should not be taken as a threat. Does that count? Can you make a threat about your firearms and then just be like, but that wasn't a threat? And that like fixes that? I'm a little bit perplexed about that. He claimed that for years he had been paying her a salary through his company and that he may choose to notify the IRS so that they could collect back taxes from her. Over the period of the indictment, as well as before that period, Mr. Fox sent her a vast number of emails in which he told her about the various steps he was taking to humiliate her, to damage her reputation, to undermine her relationships with her children, her spouse, her friends, and her employer. And, he stated, he hoped, to make her unemployable and homeless. This is nuts. We've seen way less get pretty serious restraining orders. I don't understand. Maybe it's because they were moving from the US to Canada, like all around, but this is nuts. He was always explicit about his intentions. In an email on July 23rd, 2014, before the period of indictment, he said, I will destroy you slowly and incrementally. Every moment of my life is focused on the single goal. He said similar things throughout the period of indictment. In a blog post on May 23rd, 2016, near the end of the period of the indictment, he struck out at critics of his website and gloated that their criticism had increased the website's public profile. He concluded that every day this website continues to make her life a little more dreary, and that every day she gets a few steps closer to that inevitable rock bottom. He made similar comments to an RCMP officer who interviewed him after his arrest. He succeeded in many of his appalling objectives. He placed untenable challenges on her relationship with G. His purpose in doing so he had outlined in an email in December 2014, shortly before the period of indictment. He wrote, I know that the best way to hurt you permanently is emotionally, not through your reputation, finances, or career. Remember, I told you many months ago that the other stuff I was doing was just to distract you. And what could be more effective than for your child to utterly despise you because of your own actions? Mr. Fox gloated about his success in damaging her relationship with G. He told her in numerous emails that she was a terrible parent and taunted her by saying that G viewed her and her other younger child with hatred and disgust. In another email, he told her he had discussed with G his plan to ruin her life, using G as a pawn to do so, and that G was okay with that plan. In an email with the subject line, your favorite child, ? He said he had told G that the mother preferred the other child. In emails in June and July of 2015, he told her that he and G, who was then around 14 years old, had been having fun at her expense by identifying 51 specific defects, which he then listed related to her personal appearance, her style of dress, her character, her cooking, and her parenting. In another email, he predicted that G would be withdrawn and sullen on returning to Miss Capuan. Oh shit, not her. In returning to the mother's home, and said that the misery will bring you and your home is far greater than a court order for you to return him. These are just some of many examples. Most, probably all, were copied to the child. It's just absolutely atrocious, to be honest with you. Making me a little bit sick. This compounded the humiliation that Mr. Fox caused his ex-wife and damaged her relationship with the child. It no doubt also caused psychological harm to the child as well. With a reorganization within her company employer, his ex-wife lost her job as a systems analyst shortly before or during the period of indictment. There was no clear evidence that the harassment was the reason that she was selected to be laid off. However, one may reasonably infer that the harassment did not help her position because it intruded significantly into the workplace, placing an extra burden on the employer, and it was seen to put other employees at risk. The ex-wife certainly saw the situation that way. Mr. Fox delighted in her loss of her employment. In an email in November 2015, he said, "You will soon be homeless. You have no money. Nobody believes anything you say anymore. Nobody is coming to your aid or defense. You will not be able to secure another job as long as that website exists, and it's not going anywhere as long as you're alive." At another time, Mr. Fox made a thinly veiled threat to interfere with her partner's livelihood by calling into question the partner's entitlement to the security clearance he required for his employment. Mr. Fox also posted personal information identifying the partner and the partner's mother, including the mother's place of work. The harassment was particularly insidious because Mr. Fox kept her in a perpetual fear of new ways he would devise to torment her. His professional expertise is in information technology, and he appeared to her to have an alarming ability to gain access to confidential information about her and the people in her life. In an email in January 2015, he threatened to infiltrate and expose her most personal life. As a show of good faith, I'll fill you in on one of the plans that I'm working on for you. What I'd like very much is to be able to add some intimate pictures of you to your website. To do that, of course, I'd have to hire someone to get close to you, pretend to be interested in you, eventually gain your trust, then eventually sleep with you. That should take what? About 3 or 4 days? Difficult to find people that unscrupulous. But for the right price, there's always someone willing to do what you want. Hooray, America! There's nothing criminally illegal about it. You may be able to pursue a claim in civil court, but I'm not going to worry about that. Okay, have a good evening, Patrick. This is insane. I haven't read all these emails before. Night, Dana. In another email around that time, Mr. Fox casually told her that he had acquired her medical records. Unofficially, of course. And he threatened future action of several types. I was pretty direct when I told the detective my intention was to do everything in my power and capabilities to make your life as miserable as possible, and, if possible, to the point that you ultimately unalive yourself. That would be my ultimate desire. But before you reach that point, it is imperative that you experience as much misery, disappointment, and suffering as possible first. At this point in your life, you have very little to lose, so there's not much incentive for me to actively publish your information. I shall wait patiently until you rise up a bit. Then proceed with the billboard campaign around Phoenix. I'll wait until you actually have some financial significance. Then publish your complete credit and financial history, including your social security number and birth certificate, which is, in parentheses, he says, not illegal as long as it's done outside the US. Again, I'm just going to say this right now. I'm not going to direct anybody to this website, but this website does still exist as far as I'm aware. He he's serving prison time for this, for refusing to take this website down. And I feel like there should, be somebody that could take this website down. I don't know how good of a fucking whatever he is that he can do that. Canada, he's in jail. This is a Supreme Court ruling. We've got a many, many, many of them to go through. We're not going to read them all tonight. We're not going to read them all necessarily, but we, oh God. Oh, interesting. I'm going to read this next part and then we're going to skip ahead. Then I have some more court for us to watch. So, I actually can't read much more, to be honest. He's so malignantly narcissistic that it is disgusting, to be honest. In an email in 2015, he told his ex that the child had once asked him if he would shoot her. I'm really concerned about any judges who are allowing him to have access to this child in any jurisdiction at any point. He's just written all this down. How could they possibly? Do you know what I mean? Like, we watch enough custody cases. We watch enough of this. This is fucked. Okay, let's continue. He once asked me if I would pew pew you. I told him that murder, oh, I guess I don't know if I can say that's illegal and immoral and can result in spending the rest of one's life in prison. And that the rest of my life in prison is not a risk I'm willing to take. But otherwise, no, I would have no qualms about it. That is how much I despise you for the things you've done and continue to do. To be clear, I told the detective the same thing. There is nothing illegal or threatening about wanting to harm someone as long as you don't act on it. I am reasonable and rational enough to know the difference and to refrain from engaging in such activity. And let me be absolutely clear on this point. I would never deliberately cause you physical harm, other than in self-defense or defense of another, though that is nothing special towards you. I have that rule for all people. Also, I emphasize that our child brought up the question and I only responded to it truthfully. Well, fucking bravo, buddy. Bra fucking. Thank you, Denali Mike. I appreciate that. The arrogance level is unreal, MB, right? Like, did I say trash talk or did I say trash talk? Like, this is too much. I'm disappointed. I'm disappointed in y'all's system, and I'm disappointed in our system. Although I do believe he's in jail right. I don't know if he's in jail still or not. But you can make people not use the internet. Why? I'm so fucking. I'm perplexed. I am so perplexed. Okay. Okay, here we go. We're gonna read a little bit about his thoughts on the. Mr. Fox submits that the jury's verdict may be taken as relating to the emails alone and not the website, but I disagree. The existence of the website with its harmful content underlays much of the harm caused by Mr. Fox's emails. As I have noted in some of his emails, he reminded her of the website or told her of new content recently or soon to be added. In one email, he asked her to let him know if anything on the website was inaccurate. In some emails, he told her about people whose attention he had drawn to the website, and in some, he told her how many people had visited that website. And he sometimes included usage graphs. Oh, that's mean. I don't know how he managed to frickin' win over some judges, Jonathan. I have no clue. Um, okay. Um, The harassment by way of the emails thus relied in large part on the existence and content of the website. Even if she did not personally read all of that content, she had a fair idea of what the website included, based on, in large part, though not entirely, on what Mr. Fox told her about it. His emails were part of the way in which Mr. Fox made sure that she suffered the intended effects of the website. Throughout and during these proceedings, Mr. Fox has maintained that the website and his emails do not amount to harassment because what they say is true. His position that there was no harassment is obviously inconsistent with the jury's verdict, but I will also make some comments about it. From the earliest stages and continuing through the proceedings, Mr. Fox held the firm view that all the statements about her were true and therefore incapable of amounting to criminal harassment. Mr. Fox's concept of truth in this context is somewhat elastic and disingenuous. For example, cross-examination in the sentencing hearing revealed that Mr. Fox's sole basis for describing her as a white supremacist numerous times on the website was that her former partner owned a dagger decorated with a swastika design. In another example, Mr. Fox's sole basis for describing her current partner as having had a life of chronic drug abuse was Mr. Fox's assumption, without actual knowledge, that the partner used caffeine, which he understood to be a drug. Caffeine? Oh my God. That's too much. That's too much. But even if Mr. Fox was convinced that his statements were true, it is abundantly clear from the evidence in the trial, as well as the evidence and submissions in the sentencing hearing, that Mr. Fox's objective was to harm her, not provide information to the public. Purporting to provide information simply gave him a convenient vehicle for the harm he was intent on causing. Now, I will skip through the sites and then right down to determining the sentences. Hold on. Because we're not going to talk about I'm going to read you guys the sentence for this one. It says, Mr. Fox, and this is obviously from the record, verbatim. Mr. Fox, I ask you to stand, please. I am going to, I'll stand too. I can stand too, Judge. That's fine. Night, Beverly. I am going to impose sentence on count 1, which is the charge of criminal harassment. I sentence you to 3 years imprisonment, followed by probation for 3 years on the conditions I will outline shortly. And on count 2, which is the charge of possessing firearms in a place other than where authorized, I sentence you to 10 months imprisonment. The 2 sentences of imprisonment are to be served consecutively. You will have credit for the approximately 17 months that you have served in pre-sentencing custody. With credit at 1.5 times, this gives you credit of 25.5 months. If the credit is applied against the total of the 2 consecutive sentences, which is 3 years and 10 months, this leaves you with a total of 20.5 months remaining to be served. The 3-year probation order, which will follow your release, will include the conditions in the written document provided to you and the court in September. I will come to these terms shortly. Before I do, I will make the ancillary orders that are to be made. Mr. Fox, you are to have no communication with her and other people that I'm not going to name. You are now prohibited from possessing any type of firearm, ammunition, crossbow, or restricted or prohibited weapon or explosive substance. That order is made under Section 109 of the Criminal Code, and its duration is for your lifetime, which I think is good. You are to provide a sample of bodily substance suitable for DNA analysis. That order is made under Section 47.051, subsection 3 of the Criminal Code. I've concluded that order is appropriate given the nature of the offenses. You are also ordered to pay a victim surcharge of $200 This is a Canadian order, Jonathan. This is a Canadian case. So this is a Canadian ruling from the Supreme Court of Canada. Returning to the probation order, it will apply for 3 years and it will include the following conditions as revised following submissions below. Statutory, you must keep the peace and be of good behavior. I think we can all agree, motherfucker ain't good behavior at all. There's none of that happening. Number 2, you must appear before the court when required to do so by the court. Number 3, you must notify the court or the probation officer in advance of any change of name or address and promptly notify the court or probation officer of any change of employment or occupation. You must report in person to this probation office. You must attend, participate in, and successfully complete any intake, assessment, counseling, or program as directed by the probation officer, including, but not limited to, attendance at forensic psychiatric services for an assessment, counseling, and treatment, except that you shall not be required to submit to any treatment or medication prescribed or recommended by the forensic psychiatric services which you do not consent. Okay, well, that doesn't help. If you do not consent to the form of treatment or medication which is prescribed or recommended by them, you shall forthwith inform your probation officer as to the reason why you do not consent. When first reporting to the probation officer, you must inform him or her of your residential address and phone number, and you must not change your residential address or phone number without written permission given in advance. You must provide your probation officer with your particulars of your employment, including any self-employment. Restrictions on movement. You must not leave British Columbia unless you have written permission of the probation officer, and you must carry the permission when you are out of the province. You must not be within 100 meters of the United States border. And you must relinquish travel documents. Restrictions to prevent harassment. You must have no contact or communication directly or indirectly with her partner, the child, blah, 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 except that you may have contact with G. You must not disseminate, distribute, publish, or make publicly available in any manner whatsoever, directly or indirectly, information, statements, comments, videos, or photographs which refer to or depict by name or description your ex-wife or any of their friends, relatives, employers, or coworkers. And within 24 hours of your release from custody, you will take all necessary steps to ensure that any website, social media page, or other publication which you have authored, created, maintained, or contributed to, which contains any information, statements, comments, videos, pictures, which refer to or depict by name or description the ex-wife or any of their friends, relatives, employers, or coworkers, including the website published under the domain, we're not putting that up there. And then they put the website down, which I'm going to put out. You must not use the internet or any computer or cellular network except as required to fulfill condition 14, aka getting rid of the website, or for sending personal emails. Oh no, I lost the privilege of sending personal emails. Wouldn't you agree with all those mean emails? And you are to provide any email address you use and a list of any email addresses you correspond with to your probation officer. Here's the other thing. Remember, if the child, and this whole case started in 2001, this child is not a child anymore. This child is 20 something years old. So sad, but still. And then there's weapons conditions. And then he speaks. He says, there is one point of clarification that I would like. With respect to bringing the RCMP to where I might have any weapons or firearms, shall I take that to mean only within Canada? Because it seems to me that I could not take them, well, given the terms of probation, I would not legally be able to bring them to firearms outside of Canada, since I can't leave Canada. Basically just admitting that he has the weapons outside of Canada. the prosecutor says it seems to me that if Mr. Fox does have other firearms or weapons in the United States that were not seized or destroyed by the ATF, probably the best thing to do would be to have him inform that officer of their whereabouts so that the officer can take steps to inform the ATF and they can take whatever steps they think are necessary. The accused says, "Well, I was thinking more, well, okay, that's fine." And then the judge says, "Would it assist, Mr. Fox, if I modify that condition so it is clear?" And he said, "Well, what I was hoping was that it could be modified to be restricted only to weapons or firearms that are within Canada. At this point, I am still quite confident that upon my release from custody, I am going to be deported." Wait, so is he American? Why the fuck would we let him here? Oh, I'm fairly confident. No, but he was deported from the US. I'm con- I'm concerned. I don't know. At this point, I'm still quite confident that upon my release from custody, I'm going to be deported, and so that I'm not really overly concerned about many of these probation conditions. But I just wanted some clarification on that one particular one because the way it's worded, literally, I would have to take an RCMP officer to wherever those firearms are located in the US, which would seem somewhat nonsensical. Oh, yeah, the RCMP does stand for the Royal Canadian Mounted Police. Thank you, Jody. The court said, "All right, the final condition will be modified so that it." She fucking gave in. Oh, okay, good. It says, "All right, the final condition will be modified so that it will read the portion that requires you to accompany a peace officer to the location in Canada of all firearms, crossbows, etc. Then there will be an additional sentence that will say at the very end of that condition, you are also to advise the peace officer of the location outside of Canada of any of the items described in this condition." Is there anything else that should be addressed? Not from the Crown, my lady. Mhm. That's what the lawyer said. And then the court said, "Mr. Fox?" And he said, "Nothing that would require clarification, but I would just like to point out that with respect to the probation conditions, once it is determined officially that I have no legal status in Canada and am not permitted to be here, if I am released from custody, I would be immediately upon my release in violation of probation, but I'll deal with that at the time if it becomes an issue." So fucking confused about his fucking. Bye, Hector. Um, all right. Now, one further matter I will raise because Mr. Fox, you have raised this a number of times. You wanted an opportunity to apply to be given audio recordings of the court proceedings in the trial, I think you said. Yes. However, I have decided I am going to have an attorney do that for me. I don't want to risk that request being denied because of the lack of knowledge or, pardon me, relevant case law on the matter. And so I'd rather have someone who's very experienced in those matters address that for me. So that will be at some point in the near future, I am sure. All right, are you content to leave things that way? The application, if it's going to be brought, should be brought to me. You understand that? Yes. All right, then thank you. We will adjourn. The Honorable Madam Justice H. Holmes. Okay. There's a little bit to deconstruct there. We have some more court to watch too, guys, so don't worry too much. See, now it's too far over there. Um, we have some court to watch too. Um, but can I get some thoughts in the chat on what you think that was like? Like, isn't that nuts? Um, I'm just like baffled that he was able to fool so many different courts into giving him what he wanted somehow. It's very, very, very troubling to me. Um, what is a squishmallow? A squishmallow is like a stuffed animal, to Allie Mike. Um, why are we asking about those? Okay, give me 1 second so I can find this thing. I need to find this. Okay. Give me 1 second. It's gonna be like 1 minute. I have to open something up, so we gotta go to the be right back screen.
In the matters 22 CF 55, 23 CF 145, State of Wisconsin versus Jacqueline Taylor. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Mr. Harrington, Eugene Harrington, Defense Counsel in person. We have Jacqueline Taylor in person in custody. We're set here today in these matters for two things. One is a sentencing hearing after revocation, and one is a motion hearing, a bond modification hearing. We do have a motion, another motion hearing filed with regards to an issue in the case, and I don't have the motion up in front of me, but that's not exactly set for today's date. I did inquire, as I had both counsel in front of me yesterday, if they wanted to proceed and argue that today. Mr. Schmidt?
Oh, I thought it was for today. I'm ready for it.
Okay, if we're ready for that, then we can. How would you like to proceed? Would you like to have the sentencing hearing after revocation first?
May we do the sentencing after revocation first?
Yes. I do have the revocation order and warrant packet in front of me. I have reviewed the packet and the information. Nothing jumped out at me as being a material fact or omission that would need to be updated on the record. But again, counsel would have better information than I do. Mr. Schmidt, did you review the packet?
I did. I don't have any corrections. I
Mr.
counted
Harry,
94 days credit.
94 days credit?
I had more than that, but, at 104 days credit. Actually, it may be more than that. I had,
Oh, yeah, no, 105. I forgot to count the JOC.
yeah, 104, 105, depending with the
So
account.
is it
today.
104? Because today would be 105?
I came up with 105, not counting today.
Okay. So I presume you would stipulate to that, Mr. Harrington?
Yes.
All right, 105 days jail credit. All right, Mr. Harrington, did you review the revocation order
I
and
did.
warrant? Did
No
you review,
additions or corrections.
and you reviewed it with Ms. Taylor?
A little bit.
And she should have reviewed, at least for the most part, some of it. She did sign that she would, or at least she spoke with her agent about it. Is that correct?
Yes.
Yeah.
All right. And so you have no information, additional information for the court, Ms. Taylor, that you found could be inaccurate?
No. She's got a statement she'll read, but
Okay. All right. So argument and sentencing recommendation, Mr. Schmidt.
DOC recommends 3 to 4 months in county jail, which means they're recommending a time served sentence with 105 days credit. DOC characterizes the offense as a misdemeanor bail jump for breaking curfew. I think that kind of understates it a bit because it had read-ins of, I believe, a narcotics drugs case and another THC case, and she was convicted of THC at the same time. I believe the court set the curfew conditions specifically for her own protection because I think the court was concerned at the time of her having overdose issues. When we look at DOC's characterization of her behavior on supervision, it doesn't appear she took it very seriously. She continued to overdose in the community. They characterized her as only getting help when incarcerated. They indicated a couple times where she either didn't report to programming or reported and left right away. There seemed to be a basic lack of regard for the rules while on supervision. I think that's especially concerning given the whole purpose of why the court put her on probation to begin with. What concerns me most of all is a big driving force of why DOC revoked her instead of just doing a sanction in this case has to do with a letter she wrote her significant other talking about the case. So I'm going to read that letter she wrote, as intercepted by the jail, as a statement that I think characterizes why I'm going to be arguing higher than the DOC's recommendation. I think the court needs to do at least 6 months and up to 12 months county jail. This was written after the incident with running from Cliff Cassidy. It reads, "Hey, what's up? So yeah, I'm back here once again. My PO put a warrant out for me and I had a hotel in Danbury. They caught me outside. You know the tribal PD cop, Cliff? Well, he got very mad at me when I took off running from him. He tried to tase me, but one of the prongs from his taser missed me and the other nicked the top of my head. I figured I'd be in a lot less trouble if I ran compared to what would have happened if I stayed, and they would have found a lot worse in my purse. So I'd say it was worth it, LMAO, exclamation point. They had the whole search team and their dogs looking for me. I was so fucking scared, but they didn't find me. I dumped everything while I was in the woods, waited for him to leave. Hours later, I got up because I fell asleep because I was so fucked up. I ended up by the campground and these two guys seen me. They were so drunk and I asked them where the casino was, so they offered to walk me there. I said, okay. Once we almost got there, I stopped and was like, I got it from here, and told them thanks. They were like, no, we are going to walk you all the way there. And they kept insisting that they bring me there. So I told them fuck off and took off the other way towards the laundromat so I could charge my phone. Next thing I know, I look and those guys were flagging down a cop and pointing towards me. I said, fuck it, and let them arrest me. Cliff said I'm the reason he hurt his arm. He's wearing a cast now. Honestly, I think his fat ass was mad because he knew he wasn't going to catch me. I got 2 new charges: resisting or obstructing officer, substantial bodily harm, soft tissue injury, which is a felony. And I got an escape charge too, which was only a misdemeanor. I talked to my PO on Tuesday and she said she wasn't going to revoke me because I completely discharged from probation on October 27th.
Thank you, Denali Mike. I appreciate that. I'm glad that you guys like hanging out here. Please make sure that you've clicked the like button today. Why would she write this, MB? Like, this is nuts. Also, she's a maker. Lemon chicken and pasta. That sounds really delicious. I get it. But you know what? You can pretend you're on West Coast time if it makes you feel any better. It's only 8:22. You good.
She told me she'd let me know what's up the next day, but I haven't heard anything until today. She sent over a release form for my medical release form for Minnesota, but I refused to sign it. My family is trying to say to her to lock me up and revoke me because I OD'd in Minnesota, but I'm denying it all. It's all hearsay. And I have rights too. I don't want no one seeing my medical records. Fuck that. So at least I can say I know they don't got shit on me. If I gotta sit here until October 27th, then so be it. I wanted to tell your crazy ass, I love you, miss you too. Never heard that from you before, but I do care about you. I honestly thought you were like mad or some at me from when we last hung out.
Hold on. Did we just get a first I love you?
I don't like how you be
Why is that? Guys. Okay. Did we just get she just said the first I love you? I think she did. This is not a phone call. This is a letter that they intercepted at the jail.
Acting when you're high, you're...
Go back. No, dude, I want you to hear you. I said that.
If I gotta sit here until October 27th, then so be it. I wanted to tell your crazy ass, I love you, miss you too. Never heard that from you before, but I do care about you. I honestly thought you were like mad or some at me from when we last hung out. I don't like how you be acting when you're high. You're all mean and rude all the time. Made me feel like you didn't give a fuck. But I'ma always care about you, and we can be friends right now. I'll always be here for you, though. I hope you're doing all right. I'll be out of here October 27th at the latest. I plan on leaving Wisconsin, though, either to Minnesota treatment program through LCO My Tribe, or I'm going to go to Florida sober living, depending if I have the money. I also got a $500 bail right now, though, LOL. I have someone to pay it, but there's no point in doing that right now because of my probation hold. Feeling lost as ASF, which means as fuck, but I keep telling myself I'll figure it out and everything will be okay. Well, keep your head up and tell me everything going on right now with you and what happened. Much love. Hope to hear from you. Hopefully I get transferred there too. I read that letter for a number of reasons.
Who was it to?
I forget his name. It wasn't Mr. St. John from this morning. Was some sort of friend or significant other. The reason I read that to the court is for a number of reasons. Following DOC recommendation to release her now would essentially validate what her whole goal was when she fled from the police. It would get her released even before October 27th, which she characterized as a pretty good outcome for all of her behaviors. I think that would be a pretty poor incentive for her behavior and contrary to the public interest to reward her in that way. I think it also strongly indicates that she intends to leave the state as soon as possible. And with these charges, I think that should be a concern. I think it also shows the fact that her criminal thinking has not really changed at all on supervision, which I think was a big goal of what probation was in this case. I think it shows that probation utterly failed, that her character did not advance at all on probation. In fact, maybe worse now, given her characterization of running from the police is a good thing because she thinks she's going to get less consequences from it. Her being proud that she's going to skate on this. DOC eventually changed their mind when they saw the letter about not revoking her. So for those reasons, I think the court needs to do something more in the 6 to 12 month range. I think that time will also be needed to ensure she has more sobriety time, because there's going to be a period of time where she's not on supervision then. Right in that letter, she's talking about dumping stuff in the woods, not sharing medical records from Minnesota related to an overdose. I think it would be dangerous to her and the community for her to be released now. And I think the 6 to 12 month range is more appropriate for this. She doesn't have that much of a criminal history. This might be her only criminal conviction. I didn't write down specifically it was or wasn't, but it's in the packet. So for those reasons, I think a higher end is necessary for this one. Thank you.
All right, Mr. Harrington.
Thank you, Judge. 3 factors in sentencing a defendant: gravity of the offense, character and rehabilitative needs of the defendant, need to protect the public. Those are the 3 factors, whether we're doing this immediately after conviction or sentencing after revocation. The defendant's convicted of misdemeanor bail jumping. The maximum penalty, I think, is $10,000 fine and 9 months in the county jail, not the year.
But I misspoke. I apologize.
We all can misspeak occasionally. Character and rehabilitative needs of the defendant. Jacqueline is 21 years old. She is a young lady. She's a mother. She has, through her behavior, put considerable distance between herself, her community, most importantly, considerable distance between herself and her family. Jacqueline's mom was always here previously, and she's not today. I know why she's not here, because I did talk to her to tell her about what was going to happen today, and we were going to have a hearing and some other things that we talked about. Jacqueline's mom is not here. Jacqueline's mom, I've known for many years for a lot of different reasons. Jacqueline's mom is now an intern with Branch 2, Sawyer County, Judge Isham. Very nice lady, but she's not here. Jacqueline is a young lady, a mom, a child. Most importantly, Judge, she's an addict. Addicts do really dumb stuff They risk themselves, they risk the community, they commit crimes, they write letters to people, notwithstanding the fact that they were told by their lawyer not to write any letters to anybody. She wrote a letter to the judge that she's going to read, but addicts do different things. Addicts oftentimes fail after treatment. The court will remember during the pendency of 22 CF 55, Jacqueline was in treatment from, I think it was January until about June of 2022. She was in treatment in Texas. She had some ups and downs, but she satisfactorily completed the treatment regimen in Texas. She came back, court put her on probation, and that was in October of 2022. And by December, when you look at the packet, she was flubbing up. So what do we do with Jacqueline? What's this court going to do? The Department of Corrections has made a recommendation recognizing all these facts that Mr. Schmidt has talked about, recognizing that there was a letter that wasn't, it wasn't privileged. It was apparently in the jail, and all over the jail upstairs, they have notices. If you send something out, we get to read it. And when you talk to him on the phone, the speaker says, this call is being recorded. Okay. Addicts do things that the rest of us don't do, or usually don't do. How do we protect society from Jacqueline, or protect Jacqueline from herself? We could do what Mr. Schmidt suggests, and that's just lock her up. I don't agree with that, because locking Jacqueline up only delays her addiction or treatment for her addiction. Jacqueline has told me she's made some arrangements with the tribe, ICO, LCO, to try to get back into the treatment regimen. She's had some conversations. They were going to do an assessment, but because she was in the Bayfield County Jail, that didn't get done. And then we, at her request, got this sentencing after revocation on relatively quickly, but Jacqueline is making some progress. I'm hopeful that this time through treatment, and she will get some treatment sooner or later, it'll be more successful than it was. She recognizes, and she's going to read a statement that she wrote, that she needs to get away from some of her old friends, old companions, those sort of things. Do we need to lock her up for 6 to 9 months? I think is more appropriate from what Mr. Schmidt was talking about. Or should we adopt the recommendation of the Department of Corrections? Let's not forget about their expertise in making recommendations about what's the appropriate sanction. We, lawyers, and the court relies on the Department of Corrections frequently. When they send a pre-sentence investigation, they make recommendations. Those recommendations are usually well thought out and appropriate, an appropriate balance of the gravity, the character, and the rehabilitative needs. I would move that urge the court to follow the recommendations in this instance, and sentence Jacqueline to 4 months in the county jail and credit the 105 days that she's already served. Thank you, Judge. Jacqueline has some things to say.
Ms. Taylor, I'm now going to turn to you. What would you like me to know? And you're going to have to pull the microphone because she's a soft talker.
Honorable Judge Morgan, I'm sorry to be in front of you today. I'm learning from my mistakes. I know I need to work on myself and my sobriety first so I can be the best mom, sister, and daughter I can be. I want the chance to fix my relationship with my son and family. I know the damage I've already done. I've been selfish in my addiction. I realize my life is important and to more than just me. Grieving and dealing with the loss of someone you love to addiction is painful and a struggle I deal with every day. I would never want to put anyone through that. I know I need help, and that's what I would want is help. I think treatment would be beneficial in my rehabilitation. I already started making arrangements through my tribe, LCO. I know I can overcome this addiction. I just have to put the work in and take it one day at a time.
Thank you. For the record, I've known Ms. Taylor since she was 15 years old when she was in front of me for juvenile court. I probably know more about her than she probably wants me to know. I have a memory. I remember pretty much everything. Ms. Taylor, you have always been a sweet young lady until you moved to hurdle with your father, and then boom, down the wrong path with the drugs, and you became an addict. And it was quick. It was like one day you were this lost little girl who was looking for love and comfort and home. The next day, you were hiding in a dryer, high.
Okay, so right until that point, I was like, wow, is the judge talking to me? She's like, you're just a little girl. She wants love. It's okay. I've not been in a dryer. Hi. I can say that. I've never been in a dryer. Hi. It's not often I can say those things. Wow. And again, that ain't weed, right? You don't get high on weed and go into a dryer. I ain't ever seen anybody that determined high. They'd be like, wouldn't it be weird if you got in a dryer? And then everyone would be like, yeah. And then nobody would get in the dryer.
And it's progressed significantly and substantially since then. To my knowledge, you've not yet gotten your GED or equivalent. I'm not certain that you have your driver's license. You're continuing down a path that will kill you. Not just a path that will destroy you and cause you harm and pain, you will die. How many times have you been resurrected from the dead? How many times have you OD'd and you needed somebody to bring you back to life? Many, many times. I don't know. I don't get those facts. I don't get those things. But when they come in front of me in cases, I don't know what it's going to take to put you back on the right track.
Hey now, this is what dreams are made of. Wake up in that dryer.
I don't know what it's going to take to put you on that path because your son wasn't enough. You need to be present for your son so he doesn't have these same feelings of alienation, of loneliness, of despair. He needs you to be present in his life and to be there and to show him what he needs to grow and be prosperous. I don't think you enjoy the life you're living right now. I don't think it brings you happiness. I hear your words on paper and I think you truly want to believe them. I believe the words more so on the letter written to whomever your love interest was of that time. I think there's a lot of fluff in that jail letter as well, because you want to act tough. You want to be tougher than you are. It's okay to be weak. It's okay to say, I need help. I hope that it's true that you are seeking the treatment and you want to go. Florida has a terrific treatment facility. I know plenty of people who have went there and it's been successful. And they
just want to make it clear. That's why I'm going to Florida too. I'm going to rehab, guys. That's what's happening. Larry B and me in rehab. I'm just joking. Sort of? Am I?
They either, some have stayed in Florida and built a great life there. Some have come back and built their life here again. It's all about avoiding the people that will bring you down, because ultimately those people don't care about you. What I heard in that letter is you're saying to whomever this is, and I love you. I know I've never heard that from you, but I love you. You're desperately seeking someone's approval and their love. But you need to love yourself first, Miss Taylor.
Oh, fuck, Judge, you hurting me. You're hurting me. And keep in mind, guys, this case is different than the case I was just reading about, okay? The case I was just reading about was about Mr. Fox. And this is a totally different case, just to be clear. But wow, the judge is really, she says she's known this girl since she was 15 years old. I don't know what's going to happen. I really don't know which way the judge is going to go here. If she's going to go for a heavier sentence or if she is going to give her this speech and then, let her go. Also, Allie B from Tennessee is here. Welcome, friend. Thanks for being here. Make sure you've clocked in for your shift by hitting that like button. We've had quite an intense night. It's trash talk night, trash talk Tuesday. So there's some trash talk that's been happening. No, this is not the dude, Billy Elliot. So just to be clear, this is a separate case from the Canadian case that I read earlier. But we will have more of that Canadian case later because that guy, spoiler alert, did not comply with court orders. So that's another case for another night. I don't like not actually seeing the chat as I'm reading. So I'll have to figure out maybe I'll do a voiceover of it one time and then I can play it while we just all chat. Oh, that's smart. That'd be smart.
You need to respect yourself first. You are a smart young lady. I've told you that from day one. I got to see your your school records. I got to see your test scores. I got to see what you're capable of until that unfortunate day, the first day you put the pipe to your lips. And then you've been downhill ever since. Just because you are now convicted of crimes does not mean that you can't move beyond that. And you can't do better. And you can't be better. And you can't be, doesn't mean that you can't be the best mom and person that you know that you're capable of. This is not the most serious crime. And Mr. Schmidt, if I'm remembering correctly, I think her first criminal conviction was a possession of THC some years ago, in 2019 or 2020. And then we have this case. So this would be your second criminal conviction. Again, if I'm remembering correctly.
Yes.
Ms. Taylor, what I heard in that letter that you wrote to whomever that was, that's not a very respectable person that's trying to skirt the law, trying to do what you want to do instead of trying to heal what's hurting. Now, I'm not here, you're not in front of me for me to sentence you for being an addict. It's for a crime that you committed, and I have to look at how serious this was. And although I heard the letter, it had a whole lot of information, not only about this case, but about a new and recent case, which I'm trying to segregate in my head, because I can't use those things in sentencing, in some sentencings. And I can't prejudge you on your actions in this 23 case, the newest case. You desperately, desperately need help, Ms. Taylor. And I'm not just talking about alcohol and/or drug treatment. You need to address your trauma that you've experienced from childhood up. You need to learn to respect yourself, because I'm guessing a whole lot of people in your life don't really respect you. And if you continue to associate with people that don't respect you, you will continue to disrespect yourself and not like yourself very much. And then that causes this vicious cycle where then you want to use more and get high more, and you want to do stupid things.
We know, Judge.
With the crime in front of me right now, it's a misdemeanor bail jumping, and the underlying offense is not significantly serious. If you were in front of me today, what would I sentence? Now, I put you on probation, and Mr. Schmidt was very accurate and true. Part of it was to save your life. Probation is not a treatment facility. It's not. Sometimes I feel that our criminal justice system has exploded into something that it is not designed to be. What our criminal justice system is mostly comprised of are addicts. And how do we get them to treatment facilities, et cetera, et cetera? We should have more mental health facilities. We should have more departments of health and human services and their departments and funding there to divert the individuals, the addicts, to treatment instead of through the criminal justice system. You are an addict. You do stupid things sometimes. Doesn't make you a stupid person. You just need to think of substances. I'm not going to sentence you based upon your ridiculous letter you wrote while in custody. And I'm not going to hold you in jail to try and keep you sober. That's not the purpose of a jail. It's not to confine you, to make sure that you don't use. As far as the revocation case 22 CF55 and the misdemeanor bail jumping, now just give me 1 second.
Wow. Interesting. So she was going to get released by the 27th at the latest date, she thought, and now we'll see what the judge does here. Another interesting case from Hector. Thank you, Hector. I know he went to bed. Thank you.
As far as that goes, based upon the facts that I have in front of me in the revocation order and warrant. Probation doesn't work for you, or it's not working for you. And so what that's going to mean in the future and with cases and all of those things, I don't know. But at this point, you've proven that probation didn't work. You weren't willing to follow probation. But with sentencing you on this matter, this underlying case, what I'm going to do is I'm going to sentence you to 135 days. So that's roughly 4.5 months. With good time, it will still be a time served. But that's because, again, I'm not using the other incident. That'll be for a jury or for other days to come. And perhaps then that letter will come in as well. But for today's purposes and what I have in front of me for the revocation, this isn't the most serious crime. You don't have a significant criminal history. And with regards to the community being at risk, in this case, in these things, you haven't shown to be a risk to the community, you're a risk to yourself. Any amount that's currently owed for fines and fees will be a civil judgment. You're always going to owe that. If you fail to pay, that means that I will issue a warrant. You could sit up to 6 months in jail. And you can ask around as it gets around of what judges do. I'm harsh with that. That means you have part of the punishment is paying your fines and fees. So if you have any outstanding, they must be paid. Otherwise, I could hold you in contempt and order you to sit up to 6 months in jail. So you have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. Now let's move on to the motion hearing.
Thank you.
Hey, Hayden and Ellie B are here, and KT is here. Welcome, guys.
I have 23 CF 145 open in front of me. I have Mr. Harrington's motion. I have reviewed the motion. I have reviewed Mr. Schmidt's response. Argument, Mr. Harrington.
Thank you, Judge. As the court notes, the defendant's charged with obstructing an officer causing soft tissue injury. That's an H felony. The elements are obstructing. An officer was doing an official act. The officer was acting with lawful authority. The defendant had knowledge the officer was acting. And then the fifth element that arises because of the jury instruction is that there has to be proof that the defendant's actions in obstructing caused, in this instance, soft tissue injury. The state's brief raises some interesting questions when you look at the instructions, and there are two instructions that really apply here. And in talking about these, it's going to give you some insight into why I brought this motion. The motion is to dismiss the four corners of the complaint. Two jury instructions, 1765 alleges resisting, and it includes in the annotations the recommendation that where there's a soft tissue injury alleged, that at the trial the court must ask that additional question. If you find the defendant guilty, did the defendant's resisting cause a soft tissue injury? And then 1766 is the jury instruction for obstructing, and the footnotes and the commentary to obstructing has none of that language about the second question, the question number 5. If you find the defendant guilty, did the defendant's conduct cause the injury? And I'm not sure why the jury instruction panel divided in that fashion. And I looked at it. I looked at Mr. Mr. Schmidt's brief, and I really thought, you know, is Mr. Schmidt correct or not? And I looked at Hennes, H-E-N-E-S versus Morrissey is the case that's cited in both the instructions, the annotations for both instructions. And Hennes and Morrissey, the unique fact about that case, or procedural posture of that case, is that was a civil case that got to the Supreme Court. And the facts were important because Mr. Hennes was charged with obstructing. The gravamen of the obstructing was the officer stopped in the middle of the night. They asked him his name, and I don't know to tell you my name.
So Allie B from Tennessee, the dryer is like a weird thing. So the judge here was explaining. Okay. Tonight has been a weird night. It's been trash talk night. We started out with a very short case where this same judge got quite sassy with somebody. Then I read out loud a Canadian case. So that's probably why T-Rex fell asleep. And but if you like my voice, well, I just read a big case or part of it. Then no, Allie B, don't worry about going back to watch because it doesn't make any sense. So then we finished that case. It was pretty intense. We got to this case, and the prosecutor in this case intercepted a letter being sent from the jail by the defendant to her love interest, let's call it. And he read this letter out loud. Now, the judge, after listening to this letter, proceeded to talk about how she had known this defendant since she was 15 years old, and that things had turned very quickly. She said she went one day from being a normal teenager to literally the next day being high in a dryer. And then there wasn't really much explanation as to what really happened with that, but that's where the dryer comes in, as far as I can tell. Now they are arguing another motion. So she was already sentenced on the previous case, and now this is I think it's a revocation motion. So let's continue. We'll watch the rest of this and see where we get to. Again, thank you guys for being here. Please make sure that you've cocked in, clocked in all the auks for your shift.
The court reviewed the record and said there was reasonable suspicion, but there was not probable cause, so that they really didn't have the ability to ask all those questions. And then the case really was about the immunity, because the posture of the case was civil case. Hennes, H-E-N-H-E-N-E-S, was suing the police officers. So it really didn't have much to do or say about obstructing and that sort of thing. All that commentary was really dicta. It didn't apply. But in Henny's case, they make reference to State versus Welch, W-E-L-C-H. And it is a case from the Wisconsin Supreme Court in 1875. And in that case, the court outlined that resisting requires some affirmative interaction vis-a-vis the person charged with it and the police officer. Running away, not talking to the police officers, wasn't resisting. Maybe obstructing, but wasn't resisting. And when you look at the jury instruction, again, we get back to the jury instruction, the instruction that includes the language about the felony question is in the resisting 1765 instruction, but not in the 1766. So my thought is that there's not clear precedent either way that one can commit felony obstructing, particularly by just running away. That's what the facts are alleged. in this case. Officer stopped her, said, "Come with me." And she said no and took off like a deer. And you heard of the letter that Mr. Schmidt read to the court where she outlined her friend. That's what she was going to do. And that's what she did. But my concern is this. I'm not so sure that a person can be charged with or convicted of obstructing where it's merely running away. There's no facts alleged in the complaint, and it's a four corners objection to the complaint. There's no facts there that show that there was actual cause, a substantial factor from her behavior to Cassidy falling down and skinning himself up. There's no connecting facts alleged there. Again, Judge, let's think about the posture of this. There isn't any case law that clearly defines this. I saw it as an issue. I raised it as an issue because I think that's my obligation as her defense attorney. I don't have a real good outline to predict this case, but I raised it as an issue. And since it goes to the facts alleged in the complaint, the four corners motion, I brought it. We're here. If the court isn't satisfied with my argument and you want more briefing, I will do that. I can't do it for the next 2 weeks, my new judge, but if you want more briefing, we can do that. That's my argument. I made the argument because there aren't any facts to support the cause in fact or substantial factor between Jacqueline running as alleged and Cassidy falling. That's my argument.
Mr. Schmidt?
I'm going to back up and talk about some historical things in Wisconsin. You will not find anything in the Constitution or the statutes that define the term cause. In fact, everyone is aware of this. It was noted when Wisconsin recodified that the legislature was intending to continue forward the common law definition of cause going forward. And that's been reinforced in all the case law. That has been called the substantial factor test. That is what it means when any statute says cause or as a result of. It uses the same test for civil versus criminal. Both civil and criminal actually have independent jury instructions for the term cause that talk about this. They essentially say that there are two ways a person can attack on the basis of, didn't cause the thing. One, that there is no but-for causation. That if you say, but for this, it still would have happened. Like we removed the defendant's actions, it still would have happened. The other way is to argue that for policy reasons, cause shouldn't extend that far. Most of the case, there is a lot of case law about substantial factor in application to criminal cases. It hasn't been applied to this because this is kind of newer. I don't think the fact that the pattern jury instruction put it in one and not the other means anything. That's why, and this is the second track I'm going to go on here. We look at the statutes. That's how we determine the meaning of the law. Wisconsin pattern jury instructions are useful when they put like specific notes explaining why they did certain things. Looking at the jury instructions and noticing an absence of explanation why they're doing something is different than them affirmatively explaining why they didn't do something. The statutes are
what?
The statutes are very clear. The legislature, which already had a substantial battery statute, created a statute that was essentially a penalty modifier for the resisting and obstructing statute. They created it such that it applied to both resisting and obstructing. They could have chosen to make it only apply to the resisting. They didn't. And given the scope of that, as well as the substantial battery statute that has the intent element, it wouldn't make sense looking at them together and looking at what the legislature wrote and say, well, they didn't mean to apply it to obstruction, even though the wording on its face does. For us to pierce that and conclude that the legislature didn't intend that, we'd have to first conclude the wording was ambiguous, and then we'd have to look to legislative intent, and then we'd have to find the legislature didn't intend that. There's no argument like that before. And which is also especially interesting because the definition of cause isn't set by the legislature, it's set by common law and cases. So I'm going to talk about some of those cases real quick. All of these are, I believe, annotated cases of the cause jury instruction. Where a substantial factor comes into play most commonly is homicide cases. There are cases where essentially, someone does something to another person, they shoot them, they stab them, they inflict a serious injury on another, they go to a hospital, and medical malpractice occurs, medical negligence occurs, a family decides to pull the plug or there's a do not resuscitate, and the defense wants to argue, I didn't cause their death, the medical doctors who messed up caused the death. State v. Bellow at the top, State v. Miller, State v. Wiley, Cranmore v. State. There's a lot of cases that are this fact pattern, and what routinely happens in each of those cases, the defendant gets denied the ability to argue that because the courts applying the substantial factor case conclude that there can be multiple things that are a substantial factor. In fact, the instruction he is citing to for resisting has the substantial factor test included, said there can be more than one substantial factor. The pattern jury instruction for cause says where there is evidence of multiple causes, you should read to the jury, there may be more than one cause of harm or consequence. The act of one person alone might produce it. The acts of two or more people might jointly produce it. So we're at a four-corner stage here. So the question is, has the state pointed to an affirmative act? The affirmative act we've pointed to is Jacqueline Taylor ran from the police, okay? We're saying that there's a chain of causation from that immediately led to an officer taking chase. He fell and injured himself. Even if it's a substantial factor that Cliff Cassidy, maybe he was clumsy, maybe he's getting old, maybe he has some sort of other physical ailment that makes him more likely to trip and fall. We're saying that it's also at least a substantial factor that he wouldn't have ran and tripped if not for Jacqueline Taylor taking flight. I think that at least gets us past four corners because it does articulate an affirmative act. There's been no argument about policy argument against this adoption. So I just don't see how this could be dismissed on a four corners argument in that manner. So that's really the core of my argument. The legislative argument giving meaning to all the words as they intended. And I do think this is affirmative act. That's why I cited Hennis versus Morrissey, because I think Mr. Harrington would agree that running from the police is an affirmative act for something. It's not an absence of getting arrested or an omission or a thing like that. And that I would say that it's at least a substantial factor in the same way that say in a Len Bias homicide, when you sell someone drugs, you don't intend for them to take too much and overdose and die, and yet you're still responsible. The affirmative act, the direct act, the legal cause and fact or actual factual legal test, the direct cause is the person themselves causing their own death. But the legislature extends that further. And in fact, you look at that instruction and how those cases are decided, they use the substantial factor test for the jury in determining whether the drugs were a substantial factor. Same thing for the crime of providing alcohol causing death, where a person provides alcohol to an underage person, they crashed the car and died. That's another homicide charge. There's nothing that's ever been said substantial factor applies only to homicides. It's the same instruction for civil as is for criminal. I think it's 1500 for civil, but that's off the top of my head. If you just search the civil pattern instructions, it's there too, and it uses the same wording as the criminal one. So for those reasons, I think that we get past the four corners stage. I think that if Mr. Harrington wants to argue to a jury, I think the question of whether this isn't a substantial factor, he was going to fall over anyways, or that you can't show that Jacqueline running was a substantial factor, I think that's a question for the jury. So that's the state's position.
Thank you. Any rebuttal?
No, I think the issues are properly before the court. My view of this, trying to preserve the record, is primarily what I was trying to do.
I do understand both sides of this, and I understand where the defense is coming from in the argument. I also understand the states. We're looking at a Wisconsin statute 946.41 paren 1, and in that it does specifically state that except as provided in subdivisions 2M and 2R, whoever knowingly resists or obstructs an officer while such officer is doing an act in an official capacity and with lawful authority is guilty of a Class A misdemeanor. Then it goes on in that part of the statute under 2R, which states whoever violates subdivision 1 and causes substantial bodily harm to an officer is guilty of a Class H felony. The facts were laid out pretty clearly in the criminal complaint, and it did present a picture to follow in your head about what exactly happened that day. The fact that Ms. Taylor was approached by law enforcement, and here Sergeant Cassidy did not want to be cooperative and intentionally ran from Officer Cassidy. Running away is a form of obstruction in this court's view. If you look at the jury instruction, and we have jury instruction, Wisconsin jury instruction for the criminal in 17.
Not sure if I buy that. Running away is obstruction. Wouldn't that just be resisting? Isn't there a separate charge for that? How is that also? How do you stack on another charge for obstruction as well? That is fleeing. Yeah, exactly, Jonathan. Like, there's a proper charge for that, and it's not obstruction. And I don't think it's like fleeing or eluding, maybe, or evading, resisting. But I find this a little difficult. I don't know. I don't know. Also, I want to go to Italy again. I've been to Italy before, but I would love to go again. Bucket list.
6.6, it does go on and it does state that the defendant obstructed the officer. To obstruct an officer means that the conduct of the defendant prevents or makes more difficult the performance of the officer's duty. Here it is very clear to the court that running from an officer who is in an official capacity with lawful authority, who is approaching the defendant, and the defendant intentionally runs from the officer, is doing an act that prevents the officer and makes it more difficult for the officer to perform the officer's duties. So the fact of running from an officer does clearly fall into...
Firenze. I don't know that I've been there. I've been to Civitavecchia. Where else? Like where Pisa is. I've been to a lot of places in Italy. I'll tell you, when you remember food, like you had delicious food somewhere and you don't know why, like it was bread, meat, like arugula. Oh, Florence is Firenze. Oh, see, so I've been there. I've been to Florence. I think that's where I had the fucking amazing sandwich in this square. And I remember being like, I'm just going to get the sandwich. And I got the sandwich. I've been thinking about it ever since. It's been 17 years. And I've just literally been thinking about that sandwich. Oh, God. Let's go to Italy, guys. Let's go for an Italian tour. Italian court tour. Actually, what we should do is a Mediterranean cruise with all of us. That'd be really
fun. The definition of obstruction. And in looking at, if we're looking at causation, now did that obstruction actually cause the injury or the injury of the officer as to what the charge is cause? Plain and simple. We can go into case law and look at civil versus criminal, but cause really means a reason for an action or a condition, something that would bring about an effect or a result. It may not be the primary cause. It may not be the sole cause. It may not be the only cause. There may be multiple causes that go into effect to create the effect of the result. But
Who will translate in Italy? Jay from Michigan? The good news is that I speak with my hands like an Italian. I don't know. We'll find somebody who can speak Italian. I shit you not. Oh my God. I'm actually just thinking about the meals that I had in Italy. Holy fucking shit. They were so good, dude. Also, I do need to make an apology to my American viewers. Some of you, you know who you are. I have outwardly berated you for not knowing about brie cheese or like eating nice cheeses. I recently found out that brie cheese is illegal in the United States in a lot of states. So I feel really bad because I was like, I remember talking to a few people and I was like, I'm perplexed that you've never tried this before. Like, who knew? Baby brie is okay? What does that even mean, Jonathan? And camembert? You're not allowed to have camembert? Oh my God. I'm like sad. So it is allowed in Tennessee, Allie? Brie spelled Brie. In Canada, I think we create some here. We have a pretty strict dairy program here, but we also import as well. Uh, yeah. Texas is okay with cheese too. Huh. And so here's a weird thing for you. American cheese. I'm sure you guys know what American cheese is. I didn't. Because we don't get American cheese here. Oh, it is legal and made here? Okay, well then I'm lying. And I'm gonna find the article and shame it that made me think that fucking brie cheese was illegal. God. Did somebody plant that to make me feel bad? I am also very high and stimulated. Okay, let's finish this off. Finish off our cheese talk for the night. We've been going for over 2 hours. Having a great night, but oh, you're talking about American cheese. You have brie and Cali too. It is so yummy. Okay, one of my favorite, I'll just say this. I call it a cheese sandwich, but I don't think it is a cheese sandwich. But if you take a fresh baguette and you put fig spread, mm, and then a little bit of mayo, but I use Kewpie mayo, so the Japanese mayo, and then I take probably like half a thing of brie and just like split it up and put it into the thing, and then potato chips in the sandwich. That's probably my meal like 3 days a week, which is why I'm fat. But seriously, it's like nothing tastes as good as skinny feels except for brie cheese. Oh, fresh matzo balls. Mm, mm. Dude, I have a video I'll post it in the Discord of this lady making these meatball subs. I've never had a meatball sub in my life. I don't know what happened. For some reason, I was talking to somebody about meatball subs. Then all of a sudden, you know how it goes in my fucking YouTube shorts when I'm scrolling through. There's a meatball sub short where this lady made the most delicious meatball subs. Amazing. Fresh mozzarella. She made the mozzarella from their family cow's milk. Chinman says in 2004, the United States government passed a law stating that any cheese aged under 60 days imported to or sold in this country must be made with pasteurized milk. And so I think that's probably what happened where you just made meatballs and sauce from meatball subs, Mayor. I'm jealous. Uh oh, but seriously, That's probably something to do with it, Tin Man, because oh my God, goat cheese, Ali B, goat cheese. I've never had a meatball sub. No, never had a meatball sub. I've never had a lot of things. People are like, why are you going to Florida for so long? Because I got a lot of shit to do down in the States. I was only in Houston for a couple days, not long enough whatsoever. I have many places to go, many people to see, and many things to eat. Um, oh my God, meatball subs last Christmas? Really? That sounds like a good Christmas meal, actually. You guys, I'm gonna post this in the Discord. You gotta check it out. The meatball subs this lady made. Oh my fucking God. First of all, she made me want to be a farmer, right? I'm not a farmer. I'm not even close to a farmer. I'm never gonna be a farmer. I want to come to Nashville. Um, but I'm never gonna be a farmer. But I'm like literally like scrolling through my phone, like maybe I should start a farm. I mean, like, why can't I? I mean, she does it. It's the problem with social media. Let's finish this. I'm gonna find that and post it.
But in looking at this case with the facts as laid out in the criminal complaint, there's enough there to believe that the intentional running from the officer, which would be obstructing the officer's ability to perform his duties, was an effect in the result of the officer running after Ms. Taylor and falling and receiving the injuries. So based upon that, the court does deny the motion as it relates to the defense's request to dismiss on four corners, as I find that there's enough there, at least for the jury to determine whether or not it believes that that action and conduct was a cause of the injury of the officer that would have led to the substantial bodily harm or soft tissue injury, creating an H felony. So motion is denied.
You want me to prepare an order consistent with that?
You sure can, yes.
It'll be short, final review, denied.
Yep, set on the record, denied. And we do have a status conference scheduled for October 12th at 11. And I believe you filed a bond request. Is that true or not true?
I didn't in this
No,
case,
no, you
Judge.
didn't. Never mind. Sorry, I was looking at the other case. All right, but I am going to amend bond myself based upon the hearings here today. I'm going to, I'll leave the $500 cash, but a condition of bond will be that she may not travel outside of the state of Wisconsin without court approval. The court would allow treatment as long as the court receives all of the details about the treatment, when you're going to go, where you're going to go, how long it's going to be, and whatnot. And that she assures her appearance for court, which could be granted by Zoom. Anything further, Mr. Schmidt?
I just want to check the defense first before we break if she resides in Wisconsin right now when she gets out. I actually don't know.
Is she going to reside in Wisconsin? Well, she has to. That's the order of the court.
I was listening with one side and
Yeah.
not, what was the question?
Does she live in Wisconsin when she gets out?
Yes.
Okay.
Her
So-
her address is not 110 West Hazel, that's her mom's address at this point, and that's not where her mom is living anymore. That's the last address they had.
And she is under bond, so if you do bail out Miss Taylor, and you are going to reside somewhere, and I'm not saying that that's where you're gonna live, if you're going to lay your head on a couch for more than 2 days, you must inform the court of that address. And your attorney. But your attorney will be out of town for a couple weeks. Anything further?
Not for me.
Not for me.
All right, then we are adjourned.
Wow, we are adjourned. Oh my gosh. First of all, thank you, Judge. Just appreciate you entirely because I thought that judge was really good. I think she really spent a lot of time thinking and working with the cases that we saw with her. She was pretty sassy, but I think that's pretty good. Denali Mike says, has anyone seen any good movies lately? We are gonna do a movie night in the Discord soon. I'm just working on that. Melanie's got a Discord too. Jonathan just posted it, you guys. What a great evening. I really had a lot of fun tonight. Thank you for sticking with me as we did something a little bit different. Appreciate that you guys have gone ahead and given me a like, because I know everybody that's still here has already done that. Please do check out the Discord that I posted as well, because I posted the meatball sub short in there. It's under the dinner table pics. I want to make that soon. I think we should try and make that, and I'll make the cheese from scratch. I'll make cheese from scratch for sure. Love it. Anyways, you guys, and thank you again, Jonathan. What a great reminder. Thank you again to Hector Cam Clips. You should download Discord, Jay from Michigan. That is where we sort of hang out during the day for the most part. If you need to get a hold of me, Discord is probably your best bet. Barbie was so good, by the way. 1,000% loved that movie. I'm still, if we look at my, we'll just show you, because I pay for YouTube Premium, so my YouTube Music, look at one of the top songs. It's a Barbie song, just on my homepage. Anyways, you guys, I love you so much. Please remember that. Remember that I'm proud of you. And, this is a secret. I'm going to do a daytime stream tomorrow in the morning. So keep an eye out for that. I don't know what time yet, but give it a try. Maybe I'll make something yummy to eat. Anyways, you guys, take your meds. Be good. Remember that I love you. I'm proud of you. And I'll see you tomorrow. Bye. KCC After Dawn. I love it, Jonathan. Bye. I've been looking for a beaver recipe lately, but no luck. No luck. Just Chuck.